So rules are basically, they're legal obligations and breaches, right? So yeah, the Facebook objections, I've had it go both ways. I just had it like 2 weeks ago, and I initially won it, and then we kept talking and I lost it, which happens, right? But I limited it to about this incident and that kind of stuff, because on Facebook it can really, there's the example of some daughter of some famous person was hiking on a mountain when she had a pending claim in New York, if you guys have written it. So there's a real disconnect, and really on the plaintiff side you got to be credible throughout. There's a disconnect if you're complaining about all kinds of stuff and then your Facebook page looks like you have a great life, which is what everybody's Facebook page looks like, right? Similarly on the defendant is the example I showed you. So rules. So what you want to do is establish what the contract said or the custom and practice required or what the rule was and how violated. And that's basically the case. And on liability on the plaintiff side, that's your case. On the defendant side, those are your affirmative defenses. Establish what it was and get them to agree to it. So I have some examples. They're in long detail in the material, but I want to run through a couple. So, rules for hotels and ICE, you can get them from different examples. You can do what you do, what you're supposed to do. Aren't you supposed to keep your walking surface safe for guests? Why? Because it can hurt them, as we can go through this. But, and it works both ways, and frankly a defendant should admit that because it is what it is. The question is, where do you get your rules from? You can get them from standards, you can get them from insurance agreements, you can get them from just common sense stuff, and that's kind of starting from left field. You want to establish those rules. Would you agree with me? You got to look out and be vigilant about when you're driving. You got to look carefully to make sure you see what's going around. And why not? Then you ask them, why not? Well, the reason why you got to keep your floor not slippery is because your guests can get hurt. You got to look out in front of you because otherwise you're going to hit somebody. If you had to provide the goods and services in this contract, well, that's the rule. The contract cases inform themselves. And on the defense side, don't you think you should go out and work? Don't you think you should have to go out and get medical? And these go through, and this is talking about, and every slip and fall case, every ICE case, yeah, they're hard cases, but every time, if you dig enough, you have written standards, because all hotel chains, all kinds of places have these slip and fall standards. And so you can do that. Insurance companies, when they write commercial policies, many times give their insureds, here's our slip and fall policy, because the commercial insurance people don't want a lot of accidents. So they give them, here's your slip and fall, here's your this, your that, and your that. This case, we took a deposition earlier this year. All this stuff is just from the last 6 months. My client was an insurance agent. Who slipped and fell and got hurt. So he gave me the insurance agreement from this defendant, and I said, don't you guys have these? And they said, nope, I don't have it. And then I marked it and I handed it to him, and I said, don't you have to do this? Yeah. And so he agreed to all of it. So they're really hard to get. They'll say no, no, no. And then eventually they'll say, oh yeah, we're on this group, all the schnook stores, the representative sits on the board, and they all go to the slip, trip, and fall prevention thing. So in auto crashes, here's some examples. You have to keep safe distances in front of you, and if you don't, but you got to ask them what happens if you violate the rule. What happens if you violate the rule is someone gets hurt. And here you go. Here's some examples. And you can hit people. Vehicles have, and you have to look out in front of you because vehicles can stop all of a sudden, and so can bicyclists and pedestrians. And that's what you try to do. And most of the time, if you do that, they're all going to agree with you because everybody wants to be that way. And this is 2 examples, and then talking about stop and encountering stopped cars. And then someone's arguing with me, well, you can stare straight ahead all the time but that's absurd. They don't really have to do that. And these are all in the materials too. Because you have to look everywhere. So this is another case. So, and trip and falls are a little different. It's not a snow and ice case, but you know, everybody will agree that you have to keep those areas free from those trip hazards. And this one's funny because the person was arguing with me about whether or not they could see it, and they agreed that they did not have good vision. If people are going south on you and they're not agreeing to the rule, then they're being absurd. Okay, and so you got to double down on their absurdity. And you say, wait a minute, you're telling me that you do not have to keep your floor safe for pedestrians? You're telling me you don't have to keep that? You don't have to look out safe in front of you? And then the jury doesn't want to live in a world like that, right? So then they look more absurd and more absurd. So I do the rules early. I tend to do the rules early before I get into the facts of this case. You know, I kind of come from left field on that sometimes. And so now if I have depots against anybody, now you're going to know how to prep your witnesses. But it is what it is, and they're going to have to do it anyway. It's smarter for the defendants to admit to the rules. But then when you're working, that's the other reason why you prep for depositions longer and you work with your clients, because then there's a context to these things. And you find out why they were going only 30 feet behind this car at 60 miles an hour, because all traffic does that. Or we breached the contract because such and such and so and so. So it's kind of a yes, but defense. And the rules, you really got to work on your rules. You got to get to the simple truth of the proposition. It's got to be simple and direct. It can't be a long IRAC analysis type of thing. It's got to be simple, to the point rule. And then you bounce your rules off your friends and see if they're good. On the defense side, the same thing. You know, the plaintiff has to take some responsibility, or on an informed consent issue, didn't you know that this could have happened to you? Yeah, I kind of did. Even if they didn't sign it or they don't remember what the doctor told them. Ask the defendant in a tort case or breach of contract case what they could have done differently. Here's an example. I would have given the antibiotics sooner. What could you have done differently? Tell me 3 things you learned from this incident is another good question. Or 2 things. Find out what they learned from that.